Hey, good Wednesday evening, everyone. State Representative Brad Halbrook here, along with some of my Illinois Freedom Caucus members from both chambers and our state director, Colin Mosley, along with Dan Caucus, former state representative from Decatur, and will always be a life member in the Illinois Freedom Caucus. So, welcome, gentlemen. And we also happen to have Bryan Drew, the attorney in our lawsuit that we have taken on the radical Democrats on this issue of the third readings rule. We were the original filers of that bill. And so I just wanted to kind of bring everybody together tonight, kind of give you an update on a hearing that's scheduled for tomorrow morning. And with that, gentlemen, unless there's something else I need to add, I'm just going to throw this over to Senator Chesney. You've taken the lead on this matter. Bring us up to date and kind of let us know what's going on here.
Yeah, appreciate that, Brad. And thanks for those that are listening. Just to update, this is the Freedom Caucus. What we did is we put together a complaint where we felt that the Democrats are abusing the three reading rule. And not to get too technical, we asked to have the opportunity to essentially read a bill before we vote on it. Not only is it not possible, but it's standard practice that from the Safety Act to the gasoline tax to all these various different taxes and fee increases, they do this with very little to, if any, notice. And so we don't even have an opportunity as caucus members to mount any opposition against the Democrats in the majority. And so it's our viewpoint that the Democrats have abused this constitutional requirement that allows three readings in both the House and the Senate, and that this abuse needs to be corrected through litigation. We believe any reasonable person, Democrat, Republican, or independent, even if we disagree on an issue, should have the ability to mount opposition, read the bill, and share our feedback and advocate on behalf of our constituencies. So what the Freedom Caucus did several weeks ago, this was before the caucus lawsuits, we hired Bryan Drew to represent us to litigate this matter that we ultimately believe is going to have to be before the Supreme Court. And so we'll get into a little bit more discussion, but we want to manage expectations. And the reason we want to manage expectations is because the headlines from these liberal idiots and these mainstream media outlets is going to be the Freedom Caucus lost, right? That's not what ultimately should happen if the Supreme Court correctly interprets the Constitution, but also appropriately allows all us legislators to accurately represent our constituency by reading bills before we vote on it. So we recognize that the judicial uphill climb to get there, and that it's going to have to go through several levels. And so we're going to ask Bryan Drew to get not too technical, but a little technical, to kind of don't get too legally on us, but just to kind of lay out the legal path where we expect it to ultimately go, but also to manage expectations, because our first hearing's tomorrow. And we want to make sure that our listeners and our viewers, and most importantly, our constituents, have a managed expectation on what to expect. Bryan, I'll turn it over to you. We can't hear you, Bryan.
Huh.
There we go.
Can you hear me now?
You're good.
All right. Sorry. Thank you, Senator Chesney. Yes, I appreciate you trusting me with this lawsuit and the whole Freedom Caucus, because it is very important. The short version, and not get to too detailed off in the legal weeds, so to speak, basically filed a complaint asking that the courts take up the three readings rule on the budget, that because it was not done properly and followed the Constitution, we're asking that it be found unconstitutional and thrown out because of a violation of the three readings rule. Our hearings tomorrow is requesting an injunction, which that's a preliminary thing saying, hey, we want you to stop it immediately. It's a very extreme remedy. It's not granted very often. It's a very difficult legal precedent to overcome. So we have to be cognizant of that. But it's very important to ask for that because we want the court to entertain this issue on a most expeditious manner. And the best way to do that is to deal with an injunction. So that's the hearing tomorrow. both sides will provide. I've already provided some written documentation. I'm assuming Speaker Welch and President Harmon's counsel will be presenting some documentation and contrary to what we've put in. So initially, there's a lot of different courts have weighed in on this. The 5th District has pretty harshly in the accuracy firearms case. That Justice Overstreet and Justice Holder White have also chimed in on this at the Supreme Court level, but in the minority. And each time they said, well, it wasn't properly before the court at that time. So I do believe we have some traction to get this to the Supreme Court, but there is a line of cases that says that lower courts, the district courts, the local circuit court that we'll be in Sangamon County and Springfield, cannot actually weigh in on this, that only the Illinois Supreme Court can. So in only a way, an ineffective way that the legal system can do, instead of just immediately going to the Supreme Court and saying, okay, if you're the only ones that can deal with it, rule on it. You have to go to the circuit court, and there is a line of understanding, at least by some court systems, although I disagree with it, that if the circuit court judge can't deal with it, they have to rule against our request for an injunction. And this is just a procedural process to get us to the Illinois Supreme Court. So the goal is to get there and to get the Illinois Supreme Court to hear it. So that's the process. And then after the injunction's done, we come back to the actual case itself and the underlying lawsuit and their violation. And, I think the most egregious part of it is this isn't their first time. I mean, President Harmon and Speaker Welch, they've signed that when they sign off on this, it's presumed that all the constitutional requirements have been met. In fact, they certify it because they've taken an oath to follow the Constitution, and they have violated it upwards now of hundreds of times over the last few years. So it's become a regular course of a way to do business and to keep anyone from reading the bills and keep them from knowing what's in it.
Right. Yeah, I think Bryan, you gave a nice summation of this, and I don't know, Chris, Brad, Dan, if you had anything to add on this. We've seen both Democrats and Republicans join each other and vote for tax increases during our tenure, and we've seen it firsthand how they've used the violation of the 3 reading rule to short circuit the process, but also to silence the constituencies that we all represent and then make excuses for it later. A lot of times, if we remember the assault weapon ban, they violated the 3 reading rule, and they had it violated and signed before we even had an opportunity to mount any opposition against it as it relates to that 3 reading rule, and becomes a lot more problematic. And so I don't know, guys, if you had anything to add or.
Senator, I would just pile on and say that, there are ways, even in a super minority, to fight the good fight and to fight back against the radical left. And I'm just so proud of the Freedom Caucus here for fighting that fight. And so we've said it before, but you guys fight in the legislature, and now you're fighting in the courts, and it's all the fight for freedom, right?
I mean, honestly, that's why I think Senator Chesney and the whole Freedom Caucus and the representative side filed this lawsuit, because it's not just for the Republican lawmakers. This is for every citizen in the state of Illinois, whether you're Democrat, whether you're Republican, it doesn't matter, because every single one of them got left out in this budget. Nobody got to read it. Nobody got to review it. I mean, what is it? Nancy Pelosi famously said once, we need to pass it so we can find out what's in it. And that's basically what happened here. Not even the Democrats have had it for several months, but I'll bet anything that most of them hadn't read it either. So, yeah, you got all the pork barrel projects in it, and all the taxpayers get hung with the bills. So, it's just, that's the unfortunate part about this is, I just appreciate that you guys are willing to do this on behalf of all the citizens, and that's the big key here.
Yeah. Bryan, I had a question for you that I think a lot of our listeners and viewers would have an interest in knowing. Is there any substantial difference between what the caucus lawsuits have been and our lawsuit? Because it certainly seems to be there's very significant similarities, and that they've done this 2 weeks after we did. Of course, I hate to, we want to be team players, but we also have to recognize that the caucus lawsuits seem to be peculiarly very similar to ours, with just some nuances. And so answer that question, but also, could that be problematic, and throw a little bit of a cloud over our lawsuit if they're combined, and how does that all interact with ours?
Well, as of now, they're two totally separate lawsuits. Yes, theirs came a couple weeks after the one you guys asked me to file. It's on a procedural bill about venue on plaintiffs' lawsuits. It's a procedural thing. It's not great law, is the way most people view it, but it certainly doesn't have the impact that this one does, because this is the budget. This is $55 billion. This is nearly $1 billion in increased taxes. This affects every single person in the state. And the other bill, it's going to affect a handful of people, and usually corporations, because they're going to get sued in Illinois when they normally couldn't. So from just a standpoint of who it's going to affect, I mean, this lawsuit you guys have brought is going to have the big impact on everyone if it can get done. I mean, don't get me wrong. Hey, the more arrows we can shoot at this, at the supermajority who are, just trampling on the Constitution, we'll take it. But as far as in this instance, my only real concern would be as if the cases kind of got combined, and the Supreme Court, took a lesser, easier way out and said, yeah, we're going to deal with the 3 readings rule, but we're not going to do it on the budget because that's a big deal. And, that's going to have far sweeping consequences. We'll do it on this random civil procedure bill that, will affect hardly anyone. So we'll slap them down, but we'll do it over here where it really doesn't mean much other than we've slapped them down. So that's my only concern with both of them traveling forward, at the same time, is if the Supreme Court decides to weigh in on this 3 readings rule and does decide to finally, after 20 years of threatening it, to actually slap down the lawmakers and make them follow the Constitution, that they could do it in a way that really doesn't have as big an impact as this lawsuit would. So that's the concern.
Right. Gentlemen, for the sake of time, I appreciate everybody joining on. Here's how you can find us at IllinoisFreedomCaucus.org, and go to Substack and subscribe there. Leader Chairman Miller, I appreciate you and Senator Chesney, especially Senator Chesney, taking the lead on this very, very important matter. And hopefully we can get this to the Supreme Court and get a resolution that favors the Constitution, what we believe the Constitution to actually say, and make this better for all of Illinoisans, and take the power back to the people. So with that, unless there's anything else to close out with, maybe we'll say goodnight and we'll break back in when things happen. Thank you, Bryan, for taking the lead here and being with us tonight. And everybody else, with that, we'll say goodnight.
Thank you, gentlemen.